Hello, everyone. Thank you for being here. Today, we're talking about estate and legacy planning, how to keep your family out of court and out of conflict. This is a serious topic and seriously, one of the most important topics that you can consider. My name is Becky Easton. I'm a personal family lawyer licensed in Arizona and Colorado, and I'm the founder and managing attorney of Easton Law Estate and Business Planning. So before we get started, just a couple housekeeping things. Because estate and legacy planning is so important, we'll cover a few of the most common things that can happen to a family, even when you think that you've done planning. So if you want to take a minute and into another tab, pull up bit.ly/EL purple sheet, and that will take you to a quick form where you can take some notes about today's presentation and even submit questions and comments directly to us if you would like after the fact, or just keep those for yourself. And otherwise, I definitely just recommend having a pad of paper or Remarkable or iPad, however you'd like to take your notes. And so you can jot a couple things down just as they come to mind while we're going through everything today. And the best way to learn, as always, is to turn off your cell phone, close your door, close your background apps. You know, we all love to multitask. I am absolutely guilty of this as well, but this is the best way to get the most out of this time. You do deserve this time for yourself and ultimately for your family. And I want you to know also that your time is very well spent today. So if you stay tuned to the end, you'll receive a link to schedule your complimentary one-on-one meeting with me personally to talk about you and the people you love most. And we'll also talk about how you can protect them. And it's important because I honestly just have a limited amount of appointments that we can offer every month. And we offer these appointment slots only to those who take time, like you are, to get truly educated about how to think about these important decisions ahead of time. So look out for details that'll come at the end of this presentation. So let's ask the question, do you have an estate plan? I'm curious, and this really includes any sort of estate planning documents whatsoever. A trust, wills, powers of attorney, maybe you have a beneficiary deed. So, it's very common to not have anything at all. And if you don't have an estate plan, most everybody today doesn't, you're actually in line, right? About 62% of adults don't have any estate planning documents in place. And if you're talking about only adults with minor children, the percentage of those adults without an estate plan is even higher. And so if that describes you, why is it you might say that you don't have a plan? Too busy, too young, never gotten around to it, but I know I should. Didn't think about it until I became a parent. Not sure, but I know I need one. They're all completely valid reasons, and we'll talk about them all. And if you do have an estate plan, what is it that you hope to learn today? Why are you watching? Let me know what comes to mind there. Something like, I may think there are gaps in my plan, but I don't know where. I did a plan a long time ago, or I did it online, and I just haven't kept in touch with the people I named. I'm not really sure that it's going to work for me. And so if you do have an estate plan, you don't know whether it's complete, or if you don't have an estate plan at all, or maybe even just an isolated document here or there, all of your responses, all of these responses I've mentioned touch on the three biggest fears that I run across in doing estate planning. So the first one is that we understand that there's a fear of planning for it and that it'll somehow hasten its occurrence. And let me know if this at all rings true for you, because I've heard it from a number of clients, but I have good news. Honestly, I've never seen a correlation between helping a family complete their plan and then something unexpectedly happening shortly thereafter. And then another common one is this is going to take too long, or I just don't have enough time. And I totally get that. And we're going to talk through it. You'll know exactly how long our process takes and what's involved by the end of our time together today. So, this next one is actually kind of two different ones. It's either I'm not old enough or I'm not wealthy enough. And I totally understand where you are regarding these doubts, which I'll get into with my personal story here in just a little bit. And these are just very real doubts. We get it. We'll address them as we go. And if you have any of these, it's all right because you're in good company. So I want you to know that you are in the right place if you've ever thought about any of these things. So if you have someone or something that you care about and want to protect, and it doesn't matter if something is big or small, expensive or not. Maybe you're not positive a document created online will fully protect you and your family. Or maybe you're wondering whether a document created online can protect you and your family, and what the supposed danger of do-it-yourself estate planning is. So if you've ever thought that, you're in the right place. Then the big one, if you're nervous about how much this is going to cost, plus where to start and how long that process is going to take. It seems like such a big undertaking, and I absolutely hear you in that. So we're going to go over that today as well. And honestly, at the end of the day, when we talk about estate planning, the reality is that estate planning is just not about you. It's about the people you love most. Your loved ones will know how your plan is working or not when the time comes. And sadly, we hear from many of our clients when a loved one passes, but dad or mom told me that I took care of it. And now I just don't understand why we're having to go to court or why we're having to publish in the newspaper or why we have to do all these extra steps. And this is really part of what we help families do. Truly take care of it, leaving no stone unturned, making sure that loved ones aren't confused or caught off guard later. So let's talk a little bit through what you're going to learn today. Because listen, things happen, they just do. But you already knew that. You don't need to learn that from me. So here's my real question. What is it that happens next? And that's what we're going to focus on today. And we'll explore this from two perspectives, the before and the after. The before is about what happens if you had no estate plan or only a document here or there when a sad day occurs, and it will occur, no doubt about it. Your family is left vulnerable. What will they have to go through? And for each sad day that we're going to talk through here, we will also talk about it from the after perspective. So the after is how a potentially tragic situation can be turned into the best possible scenario for you and your loved ones, keeping your family out of court and out of conflict. And as you might guess, this all comes down to communication and putting things down in writing, being clear and comprehensive. Then we're going to talk about how to start, how long it's going to take, and how much it costs. And don't forget about your bonus at the end. So before we delve into all of that and meet the Bliss family, I want to tell you a little bit about myself and why I'm so passionate about helping people the way we do. So growing up, I knew I wanted to do something to help people, but never really considered law school. I grew up on Law and Order, and while I do love a spirited discussion, I did not want to spend all day, every day arguing. Having graduated with psychology and Spanish linguistics degrees, I found myself working in the tech industry thinking, I can do more. Have you ever felt that? So I realized that transactional attorneys existed and that they actually helped their clients accomplish things. Unaware that a huge recession was looming, my husband, then boyfriend, and I packed up and moved to Denver for law school in 2008. Though I would not change that decision at all, it did make finding fulfilling work after graduation quite difficult. So while I found myself in interesting positions, mortgage and foreclosure compliance, anti-money laundering investigation, HOA compliance and collections, I was involved so far down the line that I wasn't actually helping anyone. And I certainly wasn't helping people protect what they loved. And the hourly fees that I was billing did not exactly encourage attorney-client communication. So when I had the chance to go out on my own and do rewarding work that actually helped people, I jumped. Easton Law was born in 2018, and it's been our mission since to educate women, families, and small business owners just like yourselves, enabling them to make intelligent and thoughtful decisions to protect the ones they love. Our firm is different from the rest, as I've seen exactly how estate planning can fail as well. My grandmother talked about her trust, and we all knew that she had it. However, she didn't actually put any of her assets in there or follow up to update it. So, what should have been a seamless process upon her death resulted in having to open probate in a completely different state. Ugh. So, I'd like you to take just a second here to think of those people that you love and who it is who needs your protection. Who was on your mind when you registered for this program? And I'll note here, I do have some pretty cute kids on here. They're not mine. I can't claim them. I'm a proud auntie. And, really, these are the people that I love and care about and want to protect. My situation ends up being a little bit different with that opportunity, but we love them all the same, right? All right, guys, well, let's jump into learning about estate planning by getting to know the Bliss family very well. So they're going to experience 5 very sad days today, and we're going to learn by exploring what happens when that sad day occurs. And you'll likely have questions as we go, so jot those down because you can always shoot those over to me after the fact or get them answered as we go along even. So let's meet this Bliss family. We've got a beautiful family: Mark, Molly, Alexander, Benjamin, and Caroline. Mark and Molly are happily married and own their lovely home in Colorado, where they have 2 wonderful children: Benjamin, who's 12, and Caroline, who's 10. Molly also has a child from a previous marriage, Alexander. And they have joint checking accounts, and they're putting away money for retirement. They both have life insurance to make sure there's financial resources if one of them were to pass. And they both came into the marriage with a little bit of savings already. They each have a solely owned investment account, and in Molly's solo account in particular, she also has an inheritance from her parents who've passed away. But they've never had a need to touch that money, so Molly's inheritance is still sitting there in that account. The Bliss family also has pets that the kids love: Rio and Whiskers. And as I mentioned, Molly was married prior to marrying Mark. So she was married to her college sweetheart, Xavier. Xavier and Molly had a son, Alexander, who's now 15. Xavier was kind of the wild, crazy, fun guy in college, but he never settled down or got serious as a husband or as a father. So that didn't last. As a result of the divorce, Molly has primary custody of Alexander, who lives with his half siblings, and Benjamin and Caroline, and with stepdad Mark. So as a result of the divorce, Xavier updated his life insurance policy. He obviously didn't want his $1 million policy payable to Molly, his now ex-wife. He wants it payable directly to his one and only child, his son, Alexander. So Xavier made that update on his life insurance. And honestly, the fact that he has life insurance at all is probably the one responsible thing Xavier has done in his mostly party-filled life. Also, as a part of the divorce settlement, Molly got sole ownership of a vacation home that they had purchased jointly in Lake Tahoe. The Bliss family visits the vacation home once or twice a year and really enjoys it. So honestly, they're just your everyday family. But this poor family is going to be put through the ringer with your permission. We're going to put them through some very sad days in a really short period of time for us to learn a little bit more together today. So bear with me, because the ill-fated Bliss family is going to be put through an absolute train wreck. And as a side note, I hope you can get a sense of how I approach this topic of life and death. I don't take myself too seriously. I enjoy humor. And at the same time, I want you to make sure, I want to make sure that I'm conveying these really important points and teaching and educating you as a part of the process. So, okay. With this said, let's jump into sad day number 1. Well, Xavier is turning 40, and this is his big birthday. So he wants to do something he has never done before, and he's decided he wants to go skydiving. On his 40th birthday, he steps into that plane, but he's just so beside himself with excitement that he doesn't pay any attention to the safety instructions. And before you know it, is jumping out of the airplane before they even finish getting him ready with the parachute and backpack. all of a sudden it's a skydiving gone bad scenario. Adios, Xavier. But Xavier has no estate plan. Although, remember, he did do one responsible thing in his life. He had life insurance, and he named Alexander as the beneficiary. Good plan, right? Well, Xavier thought he had a plan, so to speak, by having life insurance. But what's about to unfold is anything but a thoughtful descent plan that leaves Alexander better off. Alexander is going to be worse off. Alexander's only 15. He's a minor. So he's actually pretty pumped. He's a teenage millionaire and is really excited about that very fancy red car that he is about to buy. In the meantime, Molly, as you might imagine, is nervous. She's thinking to herself, wait a minute, Alexander's only 15. $1 million is a lot of money. Can he be in charge of his own money at 15? How can I make sure he's responsible with it? He's still a teenager and needs to learn some financial lessons and responsibility. So Molly calls our office and lets us know this is going on. Well, we have to deliver the bad news to Molly that we are going to have to go through probate court to figure out who's going to be in charge of the $1 million until Alexander is an adult at 18. Probate court is required because Alexander is a minor and minors can't be in charge of their money, whether they're 6 months old or 16 years old, not until they're at least 18 or in some cases 21. So a judge must figure out who's in charge of the money in the meantime. And Molly wants that to be her, of course. As part of the process, we have to submit Molly's credit report and background check to the judge, which she considers a little invasive, but has no choice. The judge, a stranger, wants to see these things to make sure that she's a seemingly responsible person. And in Arizona, if the child is 12 or older, they may also be going to court and could be questioned by the judge as well. And by the way, everything about this court proceeding is a public record that can be searched by anyone. And it takes time because we're there on the court's timetable. So guess what, though? Who else shows up? Zachary, Xavier's brother. And this is Xavier's life insurance money, I doubt Xavier would want Molly, his ex, managing it. And it seems like he might rather his brother Zachary manage it for Alexander. So, question for you. Who does the judge choose as Alexander's financial conservator? Molly, Alexander's mom, or Zachary, Alexander's uncle? The financial conservator will manage the money for Alexander until he's 18. And so, who do you think? Molly because she's mom? Zachary because he's related to Xavier, where the proceeds came from to begin with? And, overwhelmingly, we'd think Molly, right? But honestly, the true answer is we don't know. There are no legal requirements that the conservator be the surviving parent. And there's no legal requirement that the conservator be a blood relative of the deceased person from whom the money comes. The judge has no clue who is actually a responsible adult because it's not their money, it's Alexander's money. And the judge needs to make sure the conservator is going to be responsible with it because he or she will have access to the money, but they're supposed to use it only for Alexander, not vacations or fancy boats. Molly is shocked because she knows that she would never do that. She thought this was going to be easy and she'll just be the default conservator because she is Alexander's mom, but there's no default. And whoever the judge appoints will serve until Alexander is 18 because then he's an adult. So all of a sudden you have an 18-year-old in charge of a lot of money with no oversight, no financial understanding, no requirement to check in with anybody, and he can do with it whatever he wants. So let's do a little something better for the Bliss family. So you remember that Xavier thought he had a plan because he had life insurance and because he had named his son Alexander as the primary beneficiary. He didn't know or realize what all would be entailed in this case if Alexander were a minor and that he was throwing his son into a court system. So let's fix those issues. So idea number one, Xavier decides to leave the money directly to his responsible brother, Zachary. He thinks that this is a quick and easy way to fix this. Lesson learned, don't name a minor as a beneficiary. However, and this is a huge takeaway, don't do this. You don't ever want to name anyone as a beneficiary who you wouldn't want to truly receive the money without any restrictions attached. Xavier doesn't really want Zachary to have the money. He wants Alexander to. He's just thinking he can get around probate court really easily. And here's why. Because if Zachary's the beneficiary, it's Zachary's money. As simple as that. If Zachary wants to use the money for Alexander, great. If he wants to use it for himself, great. He gets to decide because it's his money. And because it's Zachary's money, if Zachary goes through anything in his life where he might owe someone else the money, maybe he owes money to someone who sues him or a creditor or an ex-spouse, then because Zachary has ownership of all this money and someone else who Alexander doesn't even know can garnish that money directly from Zachary, leaving nothing for Alexander, then Alexander is completely out of luck. None of these people will have anything to do with Alexander or what Xavier wanted for him. It just doesn't seem fair at all. Idea number 2. So instead, Xavier signs a simple will that says, I leave everything to Alexander. If he's under 21, I put Zachary in charge. Everyone has probably heard that you need a will, so this sounds like it'll be a good plan. And not only is he saying everything goes to Alexander, but also that if Alexander is not even under 18, but under 21, that Zachary is in charge of managing the money for Alexander in the meantime. However, there's a hole in this plan, and I think it might surprise you. What Xavier didn't know at the end of the day is that 2 simple things will override your will: joint ownership and beneficiary designations. I'll give you a fair warning. So I'm going to go, we'll have a lot of words on this next slide, but I promise you there is a good reason for it here. So we're going to talk about 3 buckets: joint ownership, beneficiary designations, and your will. So when someone calls me after a loved one has passed away, the first thing I want to know is whether or not they have a will. I first want to know, it's actually not whether or not they have a will. We want to know first whether they had any jointly owned assets with anyone else. Because if they jointly owned anything with another person who is still living, that surviving joint owner, in most cases, which we won't go into all the exceptions today, in most cases, the surviving joint owner is going to get that asset regardless of Xavier's will. And then let's say that Xavier had later remarried. He owned a home prior to marriage, and then he added his new wife, Alexander's stepmom, to title. If Xavier really wants everything, including the home, to go to his son Alexander, then Alexander is not going to get the home. Because stepmom is the surviving joint owner, she will get the home, even if Xavier's will says, I leave out everything to Alexander. So joint ownership overrides Xavier's will. Then, if assets are not jointly owned, the next thing I ask is, what does the beneficiary designation say? So I'm willing to bet that you have beneficiaries designated at this very moment, whether you realize it or not. Life insurance and retirement accounts are the best examples. If the beneficiary is living, like Alexander on the life insurance, then Alexander is going to receive that $1 million outright, even as a minor, even if Xavier has a will saying otherwise. And this is because beneficiary designations override Xavier's will. And back to probate court. Plus, the probate judge doesn't have to choose Zachary as a conservator, even though he's named in Xavier's will. Remember, the will isn't legally controlling at this point. The documents-only attorney or the online software that Xavier used didn't tell him about this, and he's rolling in his grave. And then everything else that's left over after we go through joint ownership and beneficiary designations is those assets that go into Xavier's probate estate. Xavier's will now controls whatever assets fall into his probate estate, or if he didn't leave a will. State law will say what happens to those assets. And here's surprise number 1. Whenever you hear the word estate, it doesn't necessarily mean everything that you might own. It only includes those things that didn't pass to a joint owner or your designated beneficiaries. Sometimes people leave no assets that fall into their estate because the 2 levels above took care of all their assets. And here's surprise number 2, a will goes through probate court. And remember how we were at probate court when the life insurance proceeds were paid directly to Alexander? This is the same place that we have to go to file a will when someone passes away. It means that even if you have a will, your family still has to go to probate court. Every probate court is public, which is how we know about the celebrity estate planning mistakes that make the news. We can see the will of John Lennon, JFK Jr., Babe Ruth, Jackie Kennedy Onassis, and you can because they all went through the probate process. If someone leaves no will, guess where else we have to go? Still probate court. Everything going through probate requires legal notices to all the parties who are involved, even if a family member is disinherited. So if you've ever had to go through probate for a loved one, this will all sound a little too familiar. And as I've worked with many families in the past, I've found that there's an assumption that a will solves all of your estate planning problems. While it's absolutely critical that you do have a will, it's definitely not the only piece of your estate plan that you need. So now, if you're wondering, what do I do if I don't want my loved ones to have to go to court? Idea number 3, Savior gets a trust instead. And here in his living trust, he says, I leave everything to my son, Alexander. If he's under 21, I put Zachary in charge. You'll notice that this is the exact same thing he said in his will. So how does this work? Well, let's first address the elephant in the room. What is a trust anyway? So the type of trust that we're talking about here is a revocable living trust. And there are all sorts of types of trusts out there, and a lot of which serve a lot of different purposes. But the ones we're going to talk about today is how to avoid probate court. In other words, how can we say who gets what, under what circumstances, and make that happen, but not go to probate court? The revocable living trust is a will substitute in that it's like a will, but it doesn't go through probate court. So here are the 3 buckets in the context of a trust. We go through the joint ownership and beneficiary designation discussion, and we have specific steps we take for each one of your assets. We don't stop working for you just because you've signed a trust document. We need to then take steps to fund or put into your trust each of your assets one by one. First, for some assets, we update title from your name or your joint names to the name of your trust. Second, for other assets, we will update the beneficiary designations from naming, say, your minor children to the name of your trust. And third, there is no probate estate anymore. Everything you own is in the name of the trust, and your trust itself is a private document that says who gets what, making everything a lot easier and more efficient for the loved ones to handle everything. Now, I will clarify and say that whether you have a will or a trust, if you have a disgruntled heir who's just bent on causing family issues this is going to make things more difficult, whether you have a will or a trust. Although, let me go back to that. It will make it difficult whether you have a will or a trust, but it may at least discourage the not so serious disgruntled heirs from doing anything other than perhaps just complaining. So when you're thinking about a trust and funding it, you want to think about it like the toys in this little red wagon. So when you were a kid, you loved putting toys in your wagon and pulling it around. And if your sibling wanted to grab your toys out of your wagon, there was probably immediately conflict or high-pitched voices. The way to avoid the conflict and the exposure that comes with toys not being in your red wagon is the same with how a trust works. The probate court is avoided for the things that you put inside your wagon. The legal phrase for this is trust funding. And so as long as your assets are funded into your trust, meaning all of your toys are in the red wagon, then there's no probate court to get these assets passed to your loved ones. So if we look at this scenario, here, all the toys are outside of the wagon. And this is what happened here. You signed a trust, whether in an attorney's office or something you bought online. Your trust legally exists. You signed it, great. But your trust is that empty wagon. It's not avoiding probate court, and it's actually inviting conflict. So would you send your child to their first day of school with a backpack that has nothing in it? Of course not. What good would an empty backpack do? You can now see how this is a disconnect. We've got a trust. We've got the assets outside the trust, but it's not working for us. Remember my story about my grandma? It's not going to avoid probate. It's a major danger that you run into with do-it-yourself estate planning or working with a documents-only attorney. So now this is a much better scenario here with the assets inside the little red wagon. Bring it back to Xavier. He has life insurance and he gets a trust. He doesn't just leave it at that. He then updates the beneficiary designations on his life insurance policy to name not Alexander, which is what's causing all the problems here, but to name his trust instead. Remember, we don't want Alexander personally to be named as the beneficiary because we don't want Alexander to inherit the 1 million outright. So Xavier names his trust as the beneficiary of the life insurance proceeds, which means that when Xavier jumps out of the plane and doesn't make it, the life insurance proceeds check is literally written to the Xavier family trust, not to Alexander personally. The trustee of Xavier's trust, his brother Zachary, then deposits the check into a checking account in the name of the trust, and Zachary is immediately in charge of all the funds for Alexander's benefit. Plus, Zachary doesn't personally own the $1 million, so even though he's managing it, the money is safe from any lawsuits against him, any of his creditors, and a potential ex-spouse. There's no probate court necessary to make any of this happen. No court, no conflict, no delay. So lesson number 1 is that a review of all of your assets must be a part of your estate planning conversation. A document alone is not going to protect you. So, okay, this is everything that has transpired from sad day number 1. And I promise the lessons will not all take quite this long to cover. So I wanted to cover the biggest question first, which is essentially a will versus a trust. So thanks for hanging in with me. And if you have any questions, please do write them down to be sure that we are able to get them answered for you. All right, guys, sad day number 2 coming on. So it's a fun ski weekend for the Bliss family. They're all having a great time skiing up in Breckenridge for a long holiday weekend. And they brought their friend Dina with them. Dina's a longtime family, a longtime family friend. She doesn't have kids of her own, but just loves Alexander, Benjamin, and Carolyn like they were her own children. It starts a really fun 3-day weekend on the mountain. Beautiful weather to start, but unfortunately, a fog descended on the mountain quickly. Mark and Molly, who were all going down all going downhill very, very fast, lose sight of each other because of the fog. And before you know it, Mark and Molly totally collide into each other. And now we've got a skiing gone bad scenario. It's a total yard sale, skis and poles everywhere. And where are the kids? They're in ski school. Mark and Molly are the parents of minor children. What happens in an emergency situation with minors whose parents are injured or missing? Ski patrol tends to Mark and Molly, and first responders are helping out. A first responder sees a picture of the beautiful Bliss family in Mark's wallet. And now the first responder knows he needs to check in on the children to make sure that they're safe. The first responders decide to send them back to a hospital on a flight for life. And Dina gets the children from ski school and plans to get them back home and stay with them as long as necessary. Dina calls Molly's sister Mindy in Texas to let her know what's going on. Mindy hops on a plane to come be with her sister Molly and her niece and nephews. But how long is it going to take her to arrive? Can she get the next flight out today? Or is it the first flight out and not until tomorrow morning? I guess Dina will stay with the children in the meantime. And what you're about to learn may actually surprise you. And it turns out that Dina can't stay with the children. She's not a blood relative. And only blood relatives can be the temporary guardian when minor children are involved. And the parents don't have any other legal documentation otherwise, which means Dina's disqualified. She's just a friend. This is obviously a huge problem because the kids know and trust Dina. They're safe with her. If Mark and Molly could communicate, they would say, please keep our children with Dina. We completely and totally trust her. But they can't communicate. So now we're stuck in this no man's land, wondering how long it will take for Mindy to arrive. And if you're a parent of minors, this can be the scariest question of all, because what's happening is going to be very scary for your children. They won't know what's going on. They won't understand who the strangers are. And want to make sure that they're in the care of someone that you totally trust. that you know will love them. And before we even talk about resolving that issue, what about Rio and Whiskers? They had a pet sitter, but the pet sitter has no clue about what happened, and now the pets are going hungry. Maybe they will be taken to the pound because a totally annoyed neighbor is tired of hearing them barking or whining for food. So, guys, again, let's do something a little bit better for the Bliss family. Let's talk about short-term guardianship. Mark and Molly put a short-term guardianship emergency plan in place to name Dina as a short-term guardian for their kids. As a side note, when I say the word guardianship, you might be thinking, who would raise my children if I can't? And that's absolutely critical. We'll talk about it, but we'll call that long-term guardianship. And that's not what we're talking about right here. Mark and Molly are signing a legal document that says, I appoint the following people to be short-term guardians of my children, Dina included. On that list, it can be whoever Mark and Molly choose, blood relatives or not. And they make sure that they have local people on the list and that local individuals are the first to be contacted because they're in closest proximity to the children and can respond the quickest. But I want to emphasize that your plan will not work unless you share it with others. So if Mark and Molly had signed the document and filed it away, and we never actually told them it was going to be important to share the copies with anyone, then their plan is not going to work there either. No one knows the plan exists or where to find it when it's needed. In emergency situations, copies of legal documents work just as well as originals. Dina could pull up the short-term legal document on her phone and show it to a first responder, a police officer, a preschool, anyone who asks. Mark and Molly have a plan. It's personalized and tailored specifically to them and their children, and it's actually going to work when they need it. And if you have pets, the pound isn't a foregone conclusion for them. Know that you can protect your pets too with a plan in place to make sure they're cared for in the case of an emergency as well. So lesson number 2 is that guardianship is equally about what happens in an emergency as it is about who raises your children if you cannot. So sad day number 3 is upon us, guys. Molly's injuries are lingering. So Mark has recovered, but Molly's still unconscious and suffering from her injuries. Mark is currently making Molly's medical decisions for now, despite the emotional burden of the whole experience. Mindy has just landed and she immediately gets on the phone with the hospital. She wants to know what's going on with Molly, but she hits a big red stop sign called HIPAA. The doctors can't talk to anyone about Molly's condition without Molly giving explicit permission in writing. So Mindy's frazzled, she's upset, and she's yelling at the doctor. But the doctor says, I'm sorry, there's a medical privacy law called HIPAA, and it says I can't talk to you. So Mindy slams down the phone in complete frustration. So Mark has been making medical decisions for Molly before Mindy arrived, but now Mindy is here and they legally get to make decisions together. You may be thinking to yourself, but why? Mark is married to Molly. He should have the exclusive right to make Molly's decision. And the big surprise is, no, he doesn't. The law says that any interested person or persons can make medical decisions for someone who's incapacitated when there's no estate plan. And it means that Mindy and Mark are now on an equal playing field when it comes to making major medical decisions for Molly. You may think this is crazy, and Mark sure does. The law doesn't presume that your spouse has your best interests at heart or that you would personally want him or her to make your decisions. It's just any interested person or persons who can make your decisions. To the extent that there's an impasse, which you can imagine there might be, doctors will tell the interested people that it's not our call as doctors to decide who to listen to for the final say so. You'll all have to go back and duke this out in front of a probate judge. So once again, we're back in probate court. And before we actually get to court, we've got Mark who's trying to keep up with the medical bills as they pile up. He's going to learn the hard way that his hands are tied as he tries to pay his bills out of Molly's account. Remember that Molly has a savings account in her own name. She has some money in there prior to the marriage. And then when she inherited money from her parents, she put it all there. Mark's not an account owner. They never really got around to adding him when they got married. But Mark goes to the bank thinking, I'll access the account and pay Molly's bills for her. But he arrives there and hits a brick wall. The banker tells him he cannot access Molly's account because he's not an account owner. But we're married. Well, same as with medical decisions, it doesn't matter. So this may sound crazy that Mark is having to go to probate court to both prove that he's capable of making Molly's medical decisions himself and that he's a responsible person to handle Molly's finances. And who's the judge going to choose? Mark or Mindy? Mindy is just as interested in Molly's medical and financial affairs. And when it comes to the finances, Mindy is thinking, this is the inheritance from my parents, and I don't want Mark to make bad decisions with it. And she's making this very clear to the judge. Mark is really annoyed because he's thinking to himself, of course I'm trustworthy, and of course I have Molly's best interests in mind. We're married. Why can't I just access this account? It's such a big hassle. But we're at the probate court anyway, because that's what the law says you have to do when someone's name is not on an account, even if they're married, or when someone doesn't specify in advance who should make their medical decisions for them. This is a nightmare situation. So let's again do something better for the Bliss family. With Molly's medical power of attorney, Mark is solely making Molly's medical decisions, even if Mindy's there in person. So now Mindy can, of course, have very opinionated views and be as loud as she wants about any disagreements with Mark. But at the end of the day, legally, Mark has the final say so, and we don't have to go to a probate judge for permission about that. And under Molly's HIPAA release, Mindy can call the doctors and find out what's going on. Mindy is named on the HIPAA release, even though she's not Molly's medical power of attorney to make decisions. All the HIPAA release means is open communication. And most importantly, Mindy has a copy of the HIPAA release that she provides upon the doctor's request. Remember how important those copies are. Then with the financial power of attorney that Molly signed as a part of her estate plan, she's naming Mark as the sole decision maker regarding her finances. So this means that when Mark walks into the bank, he can bring the financial power of attorney with him, and he can get access to that account to pay Molly's medical bills. And this is a huge time saver because instead of having to go to probate court, Mark can immediately take this document and act under it and do this for Molly's benefit, saving him a ton of hassle and time. So here's lesson number 3. The only person other than you who can make your decisions is a probate judge. Don't let that happen. You want to take control. Sad day number 5 means that Molly is just not going to recover. Unfortunately, the doctors are here delivering this bad news, and Molly is, in their judgment, irreversibly and terminally injured. So what happens now? Who makes the call as to when to remove her from life support? That would be whoever the probate judge selected as her medical decision maker. And whoever that is making a guess as to how long Molly would want to hang on. Can you imagine? No one wants to be in this situation. Not Molly and not any of her loved ones. And you would never want to be the one to put that decision on someone else's shoulders. But Molly and Mark thought they were too young for an estate plan. You can imagine that there's going to be a lot of different views, as many different views as there are people at the hospital who care about. Maybe Mark says there's no hope and she wouldn't have wanted to remain this way. Maybe Mindy says, wait, I know a miracle would happen. She would want us to do anything in our power to help. When to terminate life support is decided as a group, and after a lot of arguing, bickering, accusations, and tears, poor Molly is removed from life support and passes away. And with Molly gone, we have another issue. Alexander, who is still a minor, unfortunately has now lost both of his parents, so he needs a long-term guardian. Mark, Alexander's stepdad, is petitioning the probate court to be Alexander's guardian, arguing to the judge, please choose me. I love Alexander like my own child. He lives with me. He won't even have to move. He's very close with his half-siblings, Benjamin and Caroline. And in the meantime, we have Alexandra, Xavier's mom and Alexander's namesake. Alexandra argues to the judge, please choose me. I am Alexander's grandmother, and I have a really close relationship with Alexander. He's my only grandchild, and I'm an adult blood relative. Obviously, I would be the right choice to raise Alexander. Alexandra has another concern too. She's thinking, if I'm not close with Mark and I have no idea, well, I'll ever see my grandson again if I don't petition this court to be his guardian. Yet in the back of her mind, she's also thinking, but I'm also getting old and I'm way past my years of raising a teenage boy, but I honestly just don't know what other choice I will have. However, the law just doesn't assume anything, especially that a relative of yours isn't crazy. Just because Alexander is related to Alexandra doesn't mean she's automatically his guardian. And a probate judge is ultimately going to decide. And remember that vacation home in Lake Tahoe? Well, Mark is about to find out that this vacation home is not paradise anymore, but a complete headache. The vacation home was solely owned by Molly as a result of the divorce from Xavier. And even though Molly has now passed away, if you were to call a county clerk in Lake Tahoe to find out who owns the vacation home, which is public record, they would look it up and say Molly, because that's Molly's name. And because Molly's name will remain on title until someone is legally entitled to transfer title out of her name into her heirs' names. And no one is legally entitled to do that until they have probate court permission first. So back to probate court to convey title from Molly's name into the new name of whoever her legal heirs are. But this vacation home is in Nevada. And remember, Molly lives in Colorado. So now we have two probate court systems to go through because every state has its own probate court. All real estate is governed by the probate court of that state. So no matter where the owner lives, out of state real estate ends up meaning double probate. You'll start a certain probate process in one place. And once you get to a certain point, we're going to have to stop. And for the Bliss family, we're going to have to tell Mark that he's going to have to open up another probate in Nevada. Likely we wouldn't, we're not licensed in Nevada if these were our clients. So he'd have to hire a completely different attorney and completely different court proceedings, double court filings, double filing fees, double attorney's fees, and all of that just to handle what used to be a paradise. So again, we are left in a nightmare situation. So let's do something better. Molly, ahead of time in her estate plan, decided her final moments. The important point is that Molly is deciding how long to remain on life support. 5 days, 30 days, no days, no more decision by committee, no more claiming by anyone to know what Molly would have wanted because she made it clear in writing. And as a part of her estate plan, Molly, and not the judge, is personally choosing the best guardian for Alexander. Molly puts in writing, I want Mark to be the guardian of my son, Alexander. A probate judge doesn't have to pit two parties against each other to make this decision. The decision is already made, and everyone knows exactly what Molly wanted. And I'm curious, are you wondering about Alexandra here? What about her concerns that she'll never see her grandson again? She's really close to Alexander, but if Mark shields Alexander from her, then what's her recourse? And this is where Molly went beyond the legal documentation to capture her wishes. Molly sat down one Saturday afternoon and wrote a letter to the guardian of Alexander, outlining her wishes if something happened to her while he was still a minor. She emphasized the importance of his relationship with his grandmother, especially because Alexander had already lost his father and Alexandra had lost her son, Xavier. Molly went above and beyond her estate plan, the actual legal document, and made it clear what it is that's really important to her. And Mark, because he wants to honor Molly and give Alexander the best childhood he can, makes sure that Alexander and Alexandra maintain their close relationship. And the vacation home can be a paradise again. Do you remember how Xavier had a trust? Well, now the Bliss family does too. And how does this work when the vacation home is, how does this work with a vacation home? And how does it end up avoiding double probate? So Mark and Molly have assets when they sit down to do the trust. Molly owns the vacation home in Nevada. They own their home in Colorado, checking accounts, life insurance, a business, cars, jewelry, lots of stuff. They decide to put the Bliss family trust in place because they want to avoid probate. But recall that they initially have an empty red wagon. So we go over each asset with Molly and Mark and together we decide that we will make sure that all of the assets, including the vacation home, are now inside the red wagon, avoiding probate. And now we end up avoiding probate in 2 states, all because we set up a trust and we put the vacation home inside of it. So lesson number 4 is that if you want control of your loved ones and your assets, you must act before it is too late. When something happens, it's a done deal. What the law says about your assets and what your family has to go through at that point. Your family can't go back and rewind anything, and they're stuck with what you did or didn't do. So finally, we're coming upon sad day number 5, guys. Many years later, Mark is old and gray and he passes away. But even after everything he went through with Molly, Mark still delayed getting an estate plan. He just couldn't bring himself to do it. Well, when he passes away, we get a call from the adult children who are all in their 30s now. But the first thing we have to talk through is the fact that the IRS always comes first. Before we get into that cut that the IRS takes off the top, a question for you. Prince passed away, leaving a $300 million estate, which is a whole lot of money. My question is, how much do you think the IRS got? Maybe 30%, half, 100 million? All valid guesses, and which are huge numbers. But actually, the IRS got around $120 million out of Prince's $300 million estate. So the estate tax is a tax on your right to transfer your property at your death, according to the IRS website. Harsh, but there is at least a little bit of relief. Everyone is allowed some amount of that is not taxed. We call it the freebie amount. So if your estate is less than that amount, there is no tax. But if it's over that amount, the excess is currently taxed at about 40%. Historically, anywhere from 35 to 55%. This freebie amount is actually quite high for a lot of people at the moment. It's $12.6 million per person. And most people don't currently have an estate tax issue, but Prince clearly did. And Congress controls the freebie amount and the tax rate. So it's important to be aware of when Congress changes it, because if you do have an estate tax problem, it can be a huge liability for your family. So once the estate tax is paid to the IRS, then whatever is left over of Mark's estate goes to each child or each adult child outright with no restrictions. What are they going to do with it? Even if they're technically adults, they may still be a little financially immature or irresponsible. Maybe they'll spend it on vacations. They didn't get the money. They don't get that the money is going to run out. Or maybe they're heavily influenced by someone who wants them to invest in their newly found business deal, and that business deal goes bad, or they lose all their money. And Benjamin, as you can see here, just goes on a total binge. So he's definitely not being responsible there. Outright distributions, whether under a will or a trust, mean that the heirs have complete control over all the money all of a sudden without restriction, oversight, or guidance. No one is there to help them make good decisions with the money, to guide them or encourage them to spend it in certain ways, or maybe even to save it or just not spend it on consumer items where there's going to be nothing to show for it once they're all done. So how can we fix these concerns with an estate plan? Let's do something better. First, you can minimize or eliminate estate tax if it's an issue for you, but only by planning ahead of time. Prince could have done this. He could have sat down with an attorney that would make clear, listen, you have a $300 million estate and a $120 million tax problem, but we can help you minimize or eliminate that tax. But again, there's a moment when it's too late. The moment Prince passed away, it was too late, and there was nothing the surviving family members could have done to avoid the estate tax at that point. And for everything else that's left after the IRS takes their cut, you can always leave it in a more responsible way than simple outright distributions. You can build in time for adult children to adjust, and you can give them a financial mentor to help them with this major change in their life. Even when they're responsible, mature adults, you may want to make sure that there's some built-in guide with your own values to help them navigate this new way of life, this new money that they now have access to. The nice thing as well is that when any assets are left and you do have this financial mentor or a trustee in place, if your child goes through anything in their life, such as a divorce or creditor issues or a lawsuit, then because their inheritance is legally in the name of your trust instead of their personal names, it's protected from your child's divorce, bankruptcies, or lawsuits. This is a major advantage of having the built-in mentor or trustee. Not only are you leaving your children a financial legacy, but you're also leaving your children protection over the money you left them if they happen to go through any kind of sticky issues in life. And the pets, at this point, they've gotten old and gray after all these years, and they need a new caretaker now that Mark is gone. He can outline in his estate plan who his pets should go to. He can even leave money to help care for the pets. He can never leave money directly to the pets, as they can't own money or walk into a bank to transact. But every now and again, you might catch an article in the New York Times about an eccentric person who left their multi-million-dollar estate to their cat, but it doesn't work out well for anyone except the lawyers representing the children challenging the will. And the takeaway here with lesson number 5 is that the IRS always comes first. And more importantly, your loved ones are going to need time to adjust. Build this in for them. And a bonus lesson for you. We've talked about many sad days today, and not the most exciting of topics, I completely recognize. And we've talked about legal documents and legal terminology. But I want to shift gears for a moment to what it is that truly matters, hands down, end of the day. When it comes to your estate plan, absolutely the legal documents matter. You need solid, tailored, personalized legal documents. But ultimately, at the end of the day, while your family will appreciate in that moment that you did an estate plan, what they're going to want for the rest of their lives is something to remember you by. What is it that your loved ones care about the most? If you don't take the time to somehow capture ways that your loved ones can remember you by, they're going to feel totally lost without you. They won't be putting your will on their nightstand to remind them of you. What it is really that your loved ones care about most, that they would be most appreciative and most thankful for you if you took the time to do. It is all about your loved ones having your insights, your values, your stories, and your experiences as a way to remember you. And this can be done in so many different ways. You can do it through letters you write, through video you record, through conversations with your family, through memories that you intentionally create with your family. What's most important is that you actually sit down and do it. And I don't feel that I'm serving you very well if I just draft the legal documents and I don't even touch on the fact that your legacy is more important than what you just did with your legal documents. So really, what I see as my purpose in life as an attorney, daughter, wife, friend, and the reason that I'm here helping client families get an estate plan in place and beginning to capture their legacy while they're doing it. And now I invite you to remember why it is you're here. Go back if you jotted down anyone's names, the people that need your protection, those people that you love and care about. The real reason that you're here today, the ones who need your protection. The people I love rely on me for protection and trust and love. And they need me to put it in legal documents in place to protect them. First and foremost, they need the legacy that I'm going to leave down for them. Your loved ones need that too. And while we've gotten through the most valuable lesson for today, let's talk about how to get an estate plan in place to protect your family. And I want to admit that there are 2 options, although not equal in quality. You could go the online document route, which it appears simple, but as we've seen, it's almost always ineffective and doesn't quite work right. Or you can go a route that is tailored and personalized. You sit down with an attorney, I hear your story, and I incorporate everything about you, what you want, and your family into your estate plan to make it very comprehensive and personalized. The traditional experience in working with the traditional attorney, and if you've worked with an attorney in the past, you can probably identify a little bit with this, is an hourly billing model. You really don't know how much anything's going to cost at the end of the day. A 1-minute call or email can result in a bill at their minimum increment of 0.1 or 0.25 hours. And then a 1-minute call is going to result in essentially being billed for 15 minutes, no matter what. And so much about the traditional practice of law is that it's a knee-jerk response to problems. The problems fall in your lap, you're disputing with another party, and you're reacting to that problem. and the attorney gives you only very limited options on how to react, when you would have had more options trying to plan in advance to avoid those problems in the first place. And then ultimately, you're a transaction, just a number. Your matter starts, your matter ends, and then you don't have any ongoing guidance as to how to avoid legal problems in the future. We have flipped the traditional experience on its head. Everything that we do is on a flat fee basis, agreed to in advance. You don't have to worry about every little call and email because we don't keep track of our time. You may have a million questions about your plan, and I promise you I've had clients who do. We're here to answer those questions and ultimately to help you make sure that your plan is exactly how you want it. Plus, I love the interaction with clients on the estate planning level because it's very proactive. We're not responding to these negative situations. It's all about what you are deciding ahead of time that you want to avoid those reactive situations for your family. And, I really do value ongoing relationships with our clients. I want to stay in touch with you over time because I know that your estate plan is not a do it once and forget it type thing. Your life is going to change and the law is going to change. I want your plan to be current and reflective of whatever's going on in your life at any time. So I will help you update your estate plan as life changes. And here's our promise to you. Your estate plan leaves no stone unturned, and it will give you that peace of mind your loved ones and assets are kept out of court and out of conflict. So here's our 3-meeting process to get your estate plan in place. The initial meeting is called your life and legacy planning session, where we will sit down one-on-one together. In advance of your planning session, you complete your family wealth inventory and assessment on your personal resource map, which is an easy and secure way to provide key information about you, your family, your assets, and your values. Really important info that I review in advance of our meeting together. At your planning session, we hit the ground running. You ask questions, I answer questions, you choose your desired estate plan, and then we start designing that plan together that day. I'll go over the engagement agreement to indicate which estate plan you choose and the flat fee, and you'll sign and make payment at that meeting. Then I'll meet with you about 4 weeks later at your signing ceremony. And this is when your plan is legally in place. So this is the big day. You can toast to champagne this day if you want. Everything that you've expressed in your wishes, as your wishes and desires, is in your legal documents. So at your signing ceremony, you'll pay the balance of the fee, if any, and then a few weeks later, we'll meet for your final meeting. And this is where we are really going to focus on the most important aspect of your plan, that your plan is an evolving thing as you and your family grow and change. All told, the process is about 8 weeks. You are going to choose from one of 3 estate plans. The first plan is the family plan. This plan is for the family who doesn't really have assets that would have to go through the probate process, but they do want to guarantee that their minor children are well cared for no matter what, that their healthcare wishes are turned into directives, and that their loved ones are able to access their assets using a durable power of attorney if they become incapacitated. This plan also includes your last will, healthcare directives, and powers of attorney, so you know that you're well taken care of if anything happens, along with the complete kids protection plan with short-term and long-term guardianship plans to ensure your children are always raised by the people you want, in the way you want, and never taken out of your home by authorities. The trust plan is a step up from the family plan. This is for the family who wants the total assurance and peace of mind of knowing your family wealth and legacy will be transferred to your heirs with the most ease and convenience possible in the privacy of our office without court involvement. You can also opt to protect your beneficiaries' inheritance from lawsuits, ex-spouses, and creditors, exactly like we covered today. Your trust plan includes all of the benefits of the family plan, plus the peace of mind knowing we will guide you during life and care for your family after. You keep your loved ones out of court, keep your affairs totally private, and ensure your family can turn to us when needed. With the trust plan, most asset transfers will be handled by you with unlimited guidance and support from us. We handle specific types of assets on your behalf. And then you have the wealth plan. And this is for families who want that total assurance and peace of mind offered by the trust plan and also want the comfort of knowing that asset transfers have been taken care of by our office. This plan is appropriate for busy families who just want the least amount of personal effort and the greatest amount of convenience and care. Your wealth plan includes all benefits of the trust plan, plus we analyze how each of your assets is titled and handle all asset transfers for you to guarantee your plan works with your family. We're going to prepare your family wealth inventory spreadsheet, which is a complete inventory of every asset that you own, and we will complete all bank, brokerage, insurance, and retirement documents to transfer title and change your beneficiary designations to your trust. In terms of the investment in your estate planning, peace of mind, a relationship with an attorney that will last your lifetime, and to be here for you during life and for your family when you cannot be, looks like this. So the flat fee investment for the wealth plan begins at $5,250 for single individuals and $5,750 for couples. And that trust plan will start at $3,750 for single individuals and $4,250 for couples. For the family plan, we're looking at $1,450 for single individuals and $1,950 for couples. You do see the pluses there. So that can also change a little bit depending on some of those levels of protection. If you built in that lifetime asset protection for your children, and we would cover those costs during your planning session. So at the end of your 3-meeting process, you take home your estate planning binder and information about how we keep in touch as your life changes. And that's just what you're taking home. So ultimately, the most important aspect of your plan is what you're creating, right? You're creating a personalized plan for your loved ones. You're capturing your family wealth in a way where your loved ones will actually know and understand your insights, values, stories, and experiences. Ultimately, you're creating peace of mind. And this is what you're taking home too, along with the estate plan. Thank you so much for giving me the opportunity to educate you guys today. So as I mentioned, there is a bonus for staying to the end. So congratulations on sticking it out with me. Your bonus as my guest today is to access my online scheduler so you can schedule your personal life and legacy planning session with me one-on-one to get started on your estate plan. So I want to emphasize again that I provide my online scheduler only to those who get this far. So I take a maximum of 7 new clients per month, and normally only 5. So appointment slots are available on a first come, first served basis, and you'll secure your appointment with a credit card. And now I'll go ahead and I'll open it up for and answer some of the frequently asked questions that I get. And so if during this time you don't get your particular question asked, please feel free to email us at info@Easton Law PLLC. We definitely want to answer your question. And also booking is open. So you can book your life and legacy planning session online at any point in time. And again, remember those appointments are first come, first served. So you just want to go ahead and check your schedule. I did throw up a QR code if you are not watching this on your phone and can have the opportunity to scan it. Otherwise, it's just lifeandlegacyplanning.aptodo.com. All right. What sort of questions do we have? This is a great one. So I don't have a large estate. Do I still need a trust? And this is a great question, which honestly I love, because the prevailing notion is that only the wealthy actually need a trust. And this is just not the position that we take. For us, it really is not about how much you own, because for other attorneys and advisors who believe this is the qualifier, some may say you need to have $100,000 before you need a trust. Another might say you need $500,000. Others say a totally different number, and the amount differs a lot based on who you talk to, which makes it not a very good indicator of whether you need a trust or not. So instead, we focus on educating our clients about how a will works and how a trust works. Specifically, what the probate court looks like without a will and how matters can be left private and efficient with a trust. This way, our clients are choosing a trust not based on an arbitrary net worth threshold, but being most educated about what their loved ones will experience when our client isn't there. So honestly, for us, it's more about the quality of the experience for loved ones than about some random dollar amount. Okay, so how long should I plan to set aside for the family wealth planning session? And what are the payment options? So I block off 2 hours for your life and legacy planning session, also called the family wealth planning session. Um, the the life and legacy planning session, I block off 2 hours and for you, and you can use as little or as much of that time as you would like. Ahead of your planning session, you complete the online and secure personal resource map, family wealth inventory and assessment. And then I will review that ahead of time and we'll most likely have a few questions. And you're then invited to ask me any questions that come to mind. We'll review your estate planning options and the fee schedule and just make sure everything is clear. You choose which plan is right for you. And then we delve into what's called the design of your plan. So this is where you begin to make those initial decisions about who will be doing what under your plan and other personalized pieces. So once we complete the design portion of your planning session, I review the engagement agreement with you where you identify which plan you've selected and what the flat fee is. And you'll also indicate which payment option works best for you. You can either choose to pay everything upfront or select a 50-50 option, paying half down and then half at our signing ceremony approximately 4 weeks later. And you can choose that best option that works for you. So let's see, if we have, or if we're planning on having more children, should we wait to do our estate plan to make sure that they are covered as well? And this is a great question. And the answer is no, not at all. So our definition of child or children always includes future born or future adopted children to take care of just that scenario. So we don't want anyone to delay doing an estate plan because they're still growing their family. Something could happen in the meantime and your family and minor children are left exposed and vulnerable. So you're always welcome to update your estate plan to reflect your child's new name and date of birth, but not at all required to in order to make sure that child is covered by the guardianship documents and inherits equally with the other children. They're covered no matter what. So if you have existing estate planning documents, how is this going to fit in to the estate planning options we have available? So as a part of our family wealth assessment that you're completing prior to your life and legacy planning session, I'm going to ask whether you have any existing estate planning documents. So if you do, I ask that you upload scans of your documents prior to your planning session so that I can review them in advance. If an existing document is as comprehensive and tailored as I would personally draft it, I'll fit it into your plan, and we don't have to redo the document just for the sake of redoing it. And if it's not as comprehensive and tailored as I would personally draft it, I'll prepare something new, tailored, and personalized as a part of your estate plan. If we do leave any existing documents in place, the flat fee is adjusted accordingly to reflect what part of your existing plan we're maintaining in your new plan. But in a lot of cases, any adjustment isn't going to significantly change the flat fee because the real value of what we offer is not a mere legal document, but all the guidance and peace of mind that comes with a well-prepared estate plan that makes your plan actually work how you want and when you need it. Oh, great question. So if I did an estate plan in one state, but I'm moving to another state, what happens to my plan? So an estate plan drafted in one state and is legally enforceable in any other state, as long as it was validly executed in the first state. However, once you become a resident of another state, you will be subject to that state's inheritance laws, which might be slightly different or largely different than your first state. So we always recommend having your plan reviewed by an attorney licensed in your new state to ensure that there isn't some nuance under those state laws that you should be aware of. So we are licensed in Arizona and Colorado, so we can help you if you move to any of those states. But beyond those states, we can assist you in finding another attorney who can help. Let's see. Oh, who should get copies of my estate plan? So, we've recommended a few we generally recommend that the first alternate that you name after your spouse or partner, if you have any, should have a copy of your estate plan. So if you're comfortable with every alternate having a copy of it, then I don't see any problem with that at all. They're going to see it anyway. So if you feel that anyone should not receive a copy in advance, I honestly ask you to consider whether you trust them with anything down the road. So for me personally, I would want to share my thoughts and advice with everyone named in my plan so that they know what's going on and can ask me questions about it. Ultimately, they're the ones, that I'm going to trust to make everything work. Oh, is there a way to expedite the process if you're having a baby? Absolutely. Absolutely. So we've worked with a lot of parents who are just about to have a new baby, just about to have their first baby, and they're ready to get their planning done. So we can always expedite the process for you. And we can also expedite meetings for anyone who's about to go on vacation or about to undergo a major surgery. Things like that are always an option as well. Oh, this is a good one too. What if I have a family member that I would just never want raising my children? How do I protect my kids? I completely hear this concern here. And with a personalized estate plan, that is one of the benefits. You don't have to worry about this for your children. So not only in an estate plan can we provide for who will raise your children if you can't, but we can also provide for exactly who you would never want to raise your children. No matter what the reason, you have the opportunity to both specify the guardian of your children and exclude someone you would never want. So during your family wealth plan or life and legacy planning session, we'll go into a lot more detail about what the best way to go about some of this is. And, is this someone you feel totally comfortable, making decisions, making it plain in your long-term guardianship plan that you would never allow to raise your children? Or is this more of a sensitive situation that you'd want to essentially keep this information private unless they were actively pursuing guardianship of your children against your wishes? It is a sensitive topic. I totally understand. And we are going to tailor your plan accordingly so that your estate plan is going to reflect your wishes and desires. And the end of the day, though, yep, you can absolutely protect your children from people that you would never want raising them as well. All right, well, I am going to go ahead and wrap up. And if there are any other questions that maybe you had on your mind or you wrote down, I definitely encourage you to email us. Again, info@Easton Law, PLLC. And again, for making it this far, guys, congratulations. Please go through and schedule your life and legacy planning session by scanning the QR or going to life and legacy planning at apptoto.com. And remember, you're going to get that session for completely free. It's $750 value. And as long as you also let us know that you made it through this, this training, you are also going to qualify for an additional $250 off. So again, thanks so much for being here, guys. I'm Becky Easton with Easton Law, Estate and Business Planning.